Good morning. This is the meeting of the Metropolitan Board of Ethical Conduct. It is June 5th, 2024, and I welcome everyone. Thank you all for coming. I want to appreciate everyone who was late last night and is impressively here this morning at this hour. So there's a lot of sleep deprivation in this room right now, but thank you all for being here sharp. Okay, we'll get started. I will ask our board secretary to take the roll call.
Chair Diani.
Present.
Ms. Carpenter.
Present.
Mr. Spraggins.
Present.
Ms. Young.
Here.
Councilmember Suara.
Present.
Ms. Grimes and Mr. Gutierrez are not present, but we have a quorum.
Thank you. Okay, that brings us to item 2, public comment period. Is anyone signed up? And no one is signed up. That brings us to agenda item number 3, approval of the minutes of April 29, 2024. The members have the minutes in their board package. I hope everyone's had a chance to review them. And may I have we'll do a motion, put it on, we'll open it up for discussion, but may I have a motion to approve the minutes?
So moved.
May I have a second?
Second.
Any discussion on the motion, on the minutes? April 29. Hearing none, why don't we just do this by voice vote? All in favor of approving the minutes of April 29, 2024, say aye. Aye. Any opposed? Hearing none. The motion passes. The minutes are approved. That brings us to agenda item number 4, notice of appeal rights. And we'll ask our board secretary to provide the notice.
After a contested hearing by this board, a party may appeal to the Chancery or Circuit Court of Davidson County by filing a writ of certiorari within 60 days. Any party wishing to pursue an appeal is encouraged to seek independent legal counsel to ensure that deadlines and procedural requirements are satisfied.
Thank you. Okay, that brings us to item number 5 on the agenda, consideration of a motion to continue filed by Carol McCoy, Arts Commission, in the matter of Joseph V. Carol McCoy. So I will just say kind of as an introduction, this is a case that we know was filed, the amended complaint filed in April 12th. We had a law department report. We went to heard that matter, dismissed some of the counts, kept another open, and scheduled it by order of May 1. We ordered a hearing on the remaining items open for today, June 5. On May 7, a timely motion to continue the hearing that was scheduled for today was filed. It was circulated to all board members, I understand, and on May 9, a timely opposition to that motion to continue was filed, a substantive opposition was filed, and that was circulated to all of us. So at this point, I trust and understand that all of the board members have read both the motion to continue as well as the substantive opposition to that motion filed by the parties to this matter. So we have argument, we've read argument, so we can decide this on the papers. Now, Ms. Joseph is with us, and I don't know if there's any...
Rebecca Lively, National Bar for Carol McCoy.
Okay. And you're here in a representative capacity?
Yes.
Okay. Because they were briefed, given the issue, it's kind of been briefed in a sense, so we could really decide it and deliberate on the papers. I'm not sure it's really necessary to have argument on this, and I guess I'll do a quick run around the table on consensus on that by board members. Does anyone believe we need argument on this, or can we decide it on the papers?
Yeah, I don't.
Okay, everyone's, so we kind of have board consensus, we'll do this on the papers. Okay, so let me just bullet summarize what I understand the motion and the opposition to be based on the motion essentially, as I read it, and we can then discuss it, we have representatives here, that Commissioner McCoy, as a commissioner, is subject to an investigation by the Metro Human Rights Commission, Title VI complaint, that the complaint before us, the ethics claim, and the MRHC complaint are closely related, that there may be witnesses, the same witnesses in both matters, and that there may be, in the future, civil litigation filed relating to these general issues, and that because of those foundation facts, the harm would be that it would be unfair to require the respondent or the witnesses of the respondent to have a hearing where they could be cross-examined and used as discovery in the Title VI complaint. That's my understanding of the argument. The opposition to that is that Commissioner McCoy is not individually noticed as an individual, and it's the entities which are the subject of the complaint, one, that the two are not closely related, although the Title VI violation, as according to the opposition filed with us, is based on the August 17, 2023 vote, which changed the funding for the certain organizations, and that this ethics complaint before us is based on racial bias while voting on August 17 at that vote, as well as general bias. So, and then the third point in the opposition is that there's future litigation, but there's always potentially future litigation at any time. Anyone speaking can always be sued for what they're. So, and the harm there is that the opposition says there'll be harm to various, I guess, moving this whole, these issues forward. Let's just, does anyone want to fill that in or have different view of it, or just talk about the characterization of either the motion or the opposition before I ask for, a motion to how we want to proceed, and any discussion on it?
Can I ask a procedural question?
Yeah, and then obviously the other question is mootness. Is there any mootness? And we may need to defer to folks in this room about what the status of the, if we decide we want to do that, we'll have to figure out what the status of the MHRC matter is, because as we know, it's in conciliation.
So my question, I know that we issued an order setting a hearing for today's date. There's not a hearing on our agenda, and so my question is, if we denied this motion, would we then try to proceed with a hearing? And if it's not on the agenda, are we putting ourselves in peril by doing that?
No, we would not proceed today with the hearing. When the motion came in with a substantive opposition to it that needed to be decided and heard, we put that on the agenda and postponed the hearing to contingent on what we decide.
Got it.
Otherwise, you'd have a big inefficiency. Everyone would have to prepare, bring their witnesses. You'd have, so for purposes of efficiency. So
effectively, there is some continuance kind of being, if not granted, practically speaking.
Logistically, it turned out that way, but I, as chair, couldn't have just ruled on the motion to continue. It needed to be by board, it needed to be by agenda, it needed to be with a quorum, it needed to be an open session, and to have everyone prepare and bring their witnesses, taking time off work and all of that, it felt inefficient. And so we will have to schedule, and the question is, do we schedule contingent on the resolution of the Human Relations Commission matter, or do we just schedule? If we deny the motion to continue, we then schedule according to our schedules and move forward. If we grant it, then we wait for a representation by the parties that the matter has been resolved, and we would then go forward and schedule it. Those are the two options that we're looking at.
Thank you for that clarification.
Thoughts, comments, views?
So do we know what the status of the Title VI complaint
That's fine.
investigation is?
Let's see if we do. Is it Attorney Cross?
Cross, yes.
Cross, can
It's
you?
the same posture as it was when the motion for continuance was filed.
And it is in conciliation.
There has been one effort at conciliation. I think they're moving towards a hearing. It's not to foreclose any other
Okay.
opportunities for conciliation. It's just, it's uncertain at the moment. I think they have scheduled a hearing.
Okay. There has been no lawsuit filed in
No.
Chancery or anything.
Correct.
I'll just jump. I'm happy for folks to think.
Well, I guess this is sort of a question, but I don't really understand how that other matter would be a basis for not proceeding with the ethics violation hearing,
Right.
unless I'm missing something.
Right. Because even if a witness is, if everyone tells the truth, then.
Right.
Yeah.
Right.
Well, and I'll follow up on that comment. The motion says it would be prejudicial to the respondent to allow the June 5 hearing to be used directly or indirectly by the complainants in a future civil suit. I don't understand how it would be prejudicial, and there's
Right.
absolutely no explanation of how it would be prejudicial. And then secondly, the board should avoid putting any witness in a situation where the witness's sworn testimony before the board may later be used in the MHRC hearing or subsequent civil. Well, that happens in the civil world. I mean, general sessions cases, your testimony can be used if there's an appeal. I don't understand why the board should avoid that. I don't see any basis. You're sworn to tell the truth, and I don't see how it could be prejudicial if the parties are abiding by that, so.
And I think if Ms. McCoy is concerned that the scope of the examination in here is somehow going to sort of open Pandora's box, we can control that by limiting the examination to the issues, that we're hearing. So I don't think that we need to worry too much about that.
Yeah, I mean, we're certainly not going to limit it beyond what we would otherwise limit it for
Sure.
because of this argument, in my sense. But I agree with you that it seems somewhat limited. It does seem somewhat limited. So, yeah, I do you have any?
I agree with what you guys said.
Yeah.
And by the way, I don't think civil litigation is a reason to, or potential civil litigation is a reason not to go forward.
Right. And I also take the point in the opposition that the Title VI complaint isn't against the individual commissioner. It's against the entity. So I also thought that was persuasive. So, any?
No. I was waiting for the lawyers too, because I don't know how this legal stuff affect each other, but I'm leaning towards the same thing. And one of the things that actually jumped at me in the opposition is the fact that there was another commissioner that is in Title VI, but at the hearing. And so if we were able to proceed with ease, then we're not able to do this. That's the rationale that I'm using. And so, but I wanted the lawyers and people that know more about law to speak, and it seems as if we're all in agreement somewhat.
So I will entertain a motion.
I move to deny the motion for continuance.
Second.
We'll do this by roll call vote.
Okay, Chair Diani,
Yes.
Ms. Carpenter,
Yes.
Ms. Grimes,
Yes.
Mr. Spriggans,
Yes.
and Ms. Young.
Yes.
It's 5 in favor.
So the respondent's motion to continue is denied, and we will now turn our attention to scheduling the evidentiary hearing in this matter. And I am going to propose that we look at July. First weekend, I'm away at the end of June for 2 weeks.
I'm out of town the first week of July.
The first week in July, yeah. I realize it's the Independence Day, and that's going to be tight. Are you back on the 8th by any chance?
Yes.
Could we look at the week of the 8th then? July 8th through the 12th? Are people mostly in town? I will throw out a date. Mondays are hard parking, but it is July. What about Monday, the 8th, at 9 o'clock? How does that work?
It works for me.
My schedule is very in flux that week.
It's very
We
what?
may be out of town on vacation, but I don't want to hold it up.
You
I
said
just
in
don't
flux,
know.
in flux.
Yes, it's in flux.
You
and-
might be out that whole week, though.
Maybe.
If you're not available Monday, you might not be available any time that
Right,
week.
so I would say,
Okay.
but there's a good chance I will be here.
Okay, okay,
You can tell how my
Okay.
family life is.
Does it work for you? Are you going to be on vacation or something?
That would be fine with me as well.
You're okay.
So what is the date you're
So we're looking at, I think we're going to, Monday, July 8 at 9 a.m.
I'm not sure, but
Okay.
but I don't get a vote, so.
Okay.
We might need you for quorum now.
Yeah.
Then don't do Monday.
It's okay.
It's okay.
All right. Okay. So we will issue an order that the hearing in the Yosef v. McCoy will be heard before us on Monday, July 8 at 9 a.m. in this conference room. And we will have a table. We didn't have it last time, but we will have a table to facilitate. Okay, great. So that completes agenda item number 5, which moves us to agenda item number 6. We have a changing of the chairs. See you in July. See you in July. Okay, that brings us to agenda item number 6, discussion and analysis of a complaint and the Department of Law's memorandum regarding Griswold v. Councilmember Joy Stiles. We have in our board packages, and we've had it since filing, so we've had it for a few weeks. I hope you've all had a chance to look carefully at all of it. We have the complaint, we have the Department of Law report dated May 6, 2024, along with its exhibits to the Law Department report. And I know, again, this board has had a chance, and I trust and understand that everyone has looked at the materials carefully. So we will now turn our attention to this matter. As we most often do, I will turn to the Law Department and see if would like to just do a brief summary of the report.
Sure. The complaint alleges that the council member violated the standards of conduct by refusing to respond to messages and engage in a professional manner with the complainant with regard to the zoning of a property, by failing to file a 2023 annual disclosure statement, and by filing a 2022 annual disclosure statement containing misleading information regarding her financial interest in real property located in Davidson County. It's the opinion of the Department of Law that the allegations concerning lack of response on a zoning matter and display of unprofessional behavior do not involve ethical matters as defined or outlined in state law and the standards of conduct. The standards of conduct require council members to file timely and complete annual disclosure statements by January 31 of each year. The complaint alleges that the council member failed to file a 2023 annual disclosure statement. Records from the Metro Clerk reflect that the council member filed her 2023 annual disclosure statement on April 18, 2024. It is the opinion of the Department of Law that the council member's alleged failure to file a timely 2023 annual disclosure statement, if proven true, could support a finding of violation of the standards of conduct. The complaint also alleges that the 2022 annual disclosure statement filed by the council member contains misleading information about her financial interest in real property located in Davidson County. The complaint alleges that the council member failed to disclose her ownership interest in the property. It is the opinion of the Department of Law that the allegation that the council member failed to disclose her financial interest in a Davidson County real property in the 2022 annual disclosure statement, if true, could support a finding of violation of the standards of conduct. In summary, the Department of Law recommends that the board dismiss the allegations numbered 1, 2, and 3 in the complaint concerning failure to respond to messages and display of unprofessional conduct. The Department of Law recommends that the board hold a hearing on the allegation numbered 4 in the complaint concerning the council member's misleading 2022 annual disclosure statement and the failure to file a timely 2023 annual disclosure statement.
Thank you. Are there any questions for the law department regarding the report, either as summarized or as written? Or for the code? Okay, I think what might make sense to proceed in proceeding, because of the nature of our body to hear from individuals who bring complaints, and why don't we take each of the kind of allegations and discuss each one, and then decide whether we'll adopt the recommendations or not of the law department. Robin, you know. So if we turn, so I guess that if we can take first the allegation of contact attempts and the failure to respond to the efforts to reach the council member. So let me just discuss, and I think the importance of our discussing things are because we are developing, our kind of principles as a body so that we hold things fair across cases. It's why we encourage everyone to look at prior cases that we have that are listed for us, so just to get a sense of how we understand code, and also for the citizens, for folks who come before us to be able to develop a sense. That's why we kind of have discussion, put it on the record, so individuals can have a sense of how does this board understand the code and the standards of conduct within the code. It's very important to, and sometimes it's very abstract when you just look at the code language, but through our discussion, it gives kind of body and meat and structure and substance to those words in the code that aren't always self-interpreting, okay? So that's my thought. So if let's just first look at this idea of contact attempts and kind of the question of whether, if true, because this is in the kind of motion to dismiss stage. If true, if everything alleged were true, would that constitute an ethical violation under our code that governs proceedings? That's the question. So let's get discussion on that. Thoughts, questions, ideas?
It doesn't seem to me to violate any of the standards, just as the Metro Law Report concluded.
So that kind of responsiveness to a citizen.
I mean, right. If true,
Yeah.
it's conduct that may be not preferable for other reasons, but I don't believe it violates any of the ethical standards.
I agree. I think our code of ethics is pretty specific as to what types of conduct it pertains to, and not all misconduct falls as an ethical issue. And, as this has come up before, there've been lots of allegations of conduct by employees or council members that we find objectionable and problematic, and I think this is one of those instances. I think council members should be responsible to their constituents, but it's not an ethical issue, so unfortunately, we don't have jurisdiction over it. I think for constituents, it would be important for them to understand that their recourse in this situation is the election process. If you have a council member that's not responsive to their constituents, the recourse would be to elect someone else.
I agree with all that.
I agree as well, as I'm looking over the standards of conduct. It doesn't look like it's falling under any of them.
Yeah.
I'm
Yeah.
sure.
Okay, yeah, I also agree with what you said, what said. Okay, so I guess I'm hearing kind of consensus on that question, on the contact attempts issue, that while it may be, not appropriate, but it's more of an electoral issue than an ethical issue. The second is language, statements made by respondent, by Councilmember Stiles, that is alleged. Again, these are allegations, and if there were hearing, who knows what we would find about what was actually said, but the allegation is what we have to look at, not proven, but the allegation is that the statement was, she said, she would never, what's alleged is that she stated to the complainant, she would never rezone any property for him, and that he should never contact her again. And that, I'll combine it with the second one, and that conduct, that communication, that speech made the complainant feel disrespected and discriminated against. So let's just take those two together. And when we, again, look at that allegation, not proven, but look at the allegation of experience of something stated, conduct that was verbal conduct that had that the the complainant experienced as discriminatory and unprofessional. Does that fall within our code such that if proven to be true, all those facts, it would constitute an ethical violation under our code?
I didn't see any allegation that there was discrimination against the complainant because of his membership in some class or some, there wasn't, there's no allegation that the council member said, I won't, rezone property for you because you're a white guy or something like that. The allegation is just, I would never rezone property for you. And, that's a personal conflict between this complainant and a council member, I think. I don't see any allegations in here that escalated to being unwilling to provide, government services to someone because of who they are or anything like that. I just don't see that allegation. So I agree with the law department's recommendation to dismiss that.
Yeah, let's talk about a little bit more about discriminatory behavior because, I mean, there's a question even if, so because we have had a case where, I don't remember the case, if the case was based, if the respondent was a council member, an elected official, or a board member, appointed official, but the respondent the allegation was that the respondent board member said, can I kind of, you're just noisy white people. And we found, and the complainant said, I felt discriminated against because why is this board member or council member referring to my race when they're telling me to be quiet, when I was petitioning on an issue? Do you know? And there, we had law department review and found that arguably, when you're talking about someone's race for no reason, you know, it could feel like racial bias, these words, but we found again that that was not an ethical, we did not find a code section that triggered that. Now, it was offensive, potentially, to anyone, but there wasn't a code section that connected with it. It was much more, because first of all, there are some free speech considerations, I remember in the report, and I'll kind of look to the law department to correct me along the way if there's different memories or if I'm misremembering anything, but that was kind of your general recollection.
It is. My recollection is consistent with that.
So, so it's, you know, there are human resource issues, you know, for employees and things. I mean, clearly, and there's, you know, maybe depending on the severity, I don't know. I mean, we're going to have to kind of, you know, kind of, it's an evolving discussion of principles and how we handle things. To get back to this, so I think that was just a kind of an asterisk on your point. I didn't want to suggest that had there been a statement for a white guy like you, I mean, that was not stated. Sure. These are not the facts alleged, but even if, you kind of posited it, and I wanted to just pull back a little bit. It's not clear that even then,
That's right.
It would be an ethical violation. So I just wanted the record to be clear.
I don't want to prejudge that situation.
Right, we won't
put it.
Right, but we did have something somewhat similar in the past, and I want to be consistent across, to the extent we can, across the years as we're developing a body of cases, hopefully that are published, and anyone can look at. We're really trying to be kind of consistent across all scenarios as they come up, whoever brings them in whatever circumstances. Okay.
And I would just note too on page 3 that
Of the report?
Of the report, sorry. That Metro Legal points out that the standards of conduct are really intended to protect and secure processes of local government from corruption. And so if you think about that being the purpose of the standards and our role in enforcing those standards, while there is objectionable conduct that has come before us before, like you just mentioned, that's not, and I think we just have to keep reiterating that that's not really the purpose of this board. And even though it's frustrating to probably the board members sometimes and to the citizens who come before us, that we have a very specifically defined role.
I agree with that.
Yeah, it's been personally frustrating for me
Yes.
as a board member because, I mean, as a layperson, you would think that racist or discriminatory conduct would be unethical, but it's not really what ethics means in this sense. So it's very frustrating, but we are confined by the code.
And I do want to, I was going to stay away from this conversation as a council person, but I felt compelled to say that I don't deal with zoning issues, but what I've seen in zoning cases is that it can get contentious between council members and residents, and the exchange could go both ways. I've seen citizens being rude to council members and things like that. After having said that, I do conclude that if these alleged exchange did happen, that is unprofessional. And I think that since our job is to represent the citizens, we should make the time to do that. There could be underlying conversations, there could be underlying exchanges that is not in this complaint, that I know that my colleague go through, where people actually curse out and say a whole lot of stuff. So we might be missing a whole lot of stuff. But if this allegation is true, I do want to say that to the residents, I feel like, okay, it's not professional to not represent people that you purport to represent. After having said that, again, the lawyers and the definition of what this board does, which sometimes I find very frustrating because you would think that it does, but it doesn't. And so I just want to put that out there, that it may be frustrating, it may be, you may not like it, and on both sides. And I said that on both sides because I've seen it on both sides. It does not constitute unethical conduct as something that this board has to take a look at. And so I want to put that out there.
Anything else? Does anyone? Okay. So that then brings us to the third item, which is the annual disclosure statements. And the Department of Law report actually helpfully kind of included example of an illustration of the question itself, as well as attaching not only the complaint, which it does, but additional exhibits to the report as background for us. So, as I understand it, there are two annual disclosure statements issues before us. One was that the most recent, 2023, was filed late, but filed accurately once it was filed late by several months. It's a January 31 due date, and it was filed sometime in April. I believe it was filed after the complaint was filed, kind of in response to the complaint. The next day, yeah. In response to the complaint, it was filed and reported. And so and we also then have the 2022 annual disclosure statement that allegedly was not complete because at the time it was filed, the property at issue was already owned and recorded, I understand, by deed, but but the 22 failed to disclose that property. That property is then disclosed in the 23. So the kind of 23 corrected, if there was an omission in 22, it was corrected by the filing of the 23 annual disclosure statement. That's why I read the facts. Any thoughts, or is that what people understand basically the facts to be?
Just to make sure I heard you correctly.
Yeah.
So the 2022 report wasn't filed at all, and then the 2023 report was filed late, and it disclosed property that would have been disclosed on the 22 report if it had been filed?
No, the 22 report was filed, and it was inaccurate.
Okay.
Because it was filed at a time when the respondent did own a property with survivor rights, but they checked no property owned. So it's inaccurate when filed in 22.
Okay.
The allegations.
Okay.
So they're two different. We have actually dealt with cases with annual disclosure problems. Failure to disclose debt, late filing. That we've had complaints and respondents before us on this issue in the past, and so we have these two issues. One late filing, and then one filing timely filing, I guess, but it was material information omitted. Or you could argue because no was checked, it was actually an inaccurate statement. So, thoughts? You can go. The code, look at the report.
It's 2.222.020R.
R, that's right, thank you. If we look at our standards of conduct code, and we look at R says, if disclosure statements are required to be filed by the employee, which includes council members, in accordance with this chapter, I guess the,
Yeah, the statement begins with employees, and
okay,
then it goes, yeah.
okay. Employees, if disclosure statements are required to be filed by the employee in accordance with this chapter, shall not fail or refuse to file in a timely manner all disclosure statements and reports, which statements and reports shall include all material information reasonably required to be included and shall not omit any material information reasonably necessary to make such reports complete and meaningful. So we have the 2023, which the only allegation is that it was late. It was a few months late. It got filed after the complaint came in the next day. So it was late by a few months. That's the 23. It was late. It was not timely. 2022, arguably didn't, it omitted, I don't, which way to say it.
Omitted material information.
Yeah, the problem is it said no, but maybe that's.
Can I point
yeah,
something out?
Yes, yeah, please.
So the question on the form is actually, do you or yourselves have a direct or indirect financial interest in any real property located in Davidson County excluding your primary residence?
Right.
And she wrote no, or somebody,
Right,
I should say
right,
wrote,
yes,
but it was
yeah.
entered as no.
Yeah,
The complaint states, for example, Councilwoman Stiles stated in her 2022 annual disclosure statement that neither she nor her spouse had a direct or indirect financial interest in real property located in Davidson County. That's actually not what she checked. They forgot the excluding your primary residence.
that's the complaint.
That's what the complaint says.
Yeah.
It doesn't fully quote that line. I don't know if this is her primary residence or not, and I think that makes a difference unless I'm really missing something here.
That's right, but I think that's why we have to have a hearing to
Yeah, well,
answer that
Yeah,
kind of
yeah.
No, I
question.
get that. I just
Yeah.
wanted to point it out because we hadn't discussed that, and I don't think
Yeah.
the complaint accurately reflects what she checked in the 2022 disclosure statement.
Yeah, I mean,
If you look at the
yeah,
complaint,
again, this is, we don't get over, I'd be concerned that may, again, be overly formalistic about requiring a complaint to cite.
no. I'm just, I guess for purposes of going forward, well, I think it's actually important because I don't think the complaint reflects what the disclosure statement says.
If I can say something.
Yeah, again, I may be missing something.
Yeah, the complaint goes on to say, for example, Councilwoman Stiles stated in her 2022 annual disclosure statement that neither she nor her spouse had a direct or indirect financial interest in any real property located in Davidson County. And then it goes on, however, records indicate that on February 25th, 2022, Councilmember Stiles and Alice Faye Stiles Reynolds jointly purchased with the right of survivorship a property at 4058 Arrowleaf Lane, Antioch. So you look at the complaint and you assume that the factual allegations are true for the purposes of.
And I understand that, but the factual, but you have attached to the report the actual disclosure statement, which is the last page, and the question that he's quoting is not fully quoted in the complaint. And so I think because you've attached that, we have the ability to read that. I'm not saying that we don't need to have a hearing. What I'm saying is I don't believe that based on all of the record that's before us, that we're, I thought that needed to be clarified based on the material that's before us. So it may or may not be a violation, and we probably need to have a hearing, but it's not per se, to me, anyway, we can go on down the road, but I wanted to point that out, because I think it's important.
It's what you're pointing out, that what was disclosed, that specific property could be her primary
It could
residence?
be. We don't know.
Okay, that's the question.
I think that's the question,
Okay.
and I think
Okay, gotcha.
that will bear on. But I just think it's important to point out that the complaint does not accurately reflect the actual disclosure statement.
If I could, so I see Ms. Carpenter's point. We don't know whether, from that report, whether that's her primary residence, but there was the 2023 disclosure that was filed late, and in response to that question, the council member disclosed that property.
Right.
So I would infer that that's not her primary residence because she disclosed it in 2023.
Right.
And who knows, I mean, she
Well,
may
it
show
could
up and
change.
say it was her primary
Right,
residence at the time,
yeah,
so.
so I just think we probably, I mean, I would lean
Get
towards
the answers to
having a
the
hearing.
question.
Because I'm,
Yeah.
And it could, and I think, again, I always sit here, and I've come to learn that, you know, when it comes to legal stuff, thank God I'm not a lawyer, I'll keep saying that, because the way the application goes back and forth. But I remember one of my first meetings here, we were considering a case, and some of the arguments that the lawyers on this team kept saying was that that was not stated in the allegation. And we decided to not do something based on that. If I remember correctly, I think they had to refile or something, I can't remember. But I'm saying that that was the statement, and at that point I'm thinking, really? But that was a statement that the complainant did not specifically state something. And because it was not stated, we couldn't hear it as a group. So where is the consistency? To the lawyers in the room, if we can use that argument in one case, why is it not applicable in this? And I'm just asking a question. So if that's the rule, and it's not specifically stated, then I'm with Ms. Carpenter in that, can we really go based on that?
So I think the question, I think that's a really good question and gives us an opportunity to kind of clarify that, so it's fabulous. And I'm going to give it a crack, although I'm feeling like I'm thinking about who else is going to clarify what I say. But I think the idea of the complaint, it has to substantially tell us what the issues are that are being complained about. Now, again, this is not for lawyers to come. We do not want people to have to hire lawyers to bring a case before us. Obviously, this is for citizens, individuals who just say, hey, I'm feeling like there was an ethical issue here. Here's my understanding of it. You guys figure it out and look at it. Could you do that? So we have to be very careful, I think, to not be overly legalistic in how they write their complaint to us. Sometimes they take a piece of paper and just literally write it out and submit it to the clerk. And then we say, okay, what is fairly alleged in the way they've described it? There will be times when something comes up where we say, but it's not fairly described. It would be a different complaint. So I agree with you, and that would be appropriate. If something's like on the side, but it's not fairly described in what the words they gave us, we'd say, well, they can file that if they want to do it, but that's not before us. But here, I do understand Ms. Carpenter's issue, and as Glad clarified, I agree, Ms. Young, that it kind of answers itself by the 23 filing that it wasn't her primary, likely. But here, I think to say, well, I think the complaint as written fairly raises the question, were these two annual disclosure statements non-compliant with the code? I think it fairly says that. And so I think we can go forward on those questions, is my view.
Great.
Yeah, I mean, I think a stronger complaint would have said, I know that that was a rental property, I saw a tenant living there during that time or something like that. And we don't have that allegation. We don't even really have the allegation that it wasn't her primary residence. But I do think the change in status from one year to the next on the form, at least we can infer that there's a question worth asking here.
And I agree with all of that. My point was really just to point out that the question is a little bit different. But I do think that the party should have the opportunity to be heard on it.
That's what, okay. Okay, so that said, I'll entertain a motion.
I move to adopt the Metro Legal Department's report as it relates to dismissing allegations 1, 2, and 3, and proceed to a hearing on allegation 4.
Do I have a second?
Second.
Okay, any further discussion? Hearing none, we'll just do a roll call vote on this.
Chair Deani,
Yes.
Ms. Carpenter.
Yes.
Ms. Grimes.
Yes.
Mr. Spraggins.
Yes.
Ms. Young.
Yes.
5 in favor.
Okay, that motion passes. We will issue an order to that effect, dismissing those portions of the complaint and keeping open the annual disclosure sections of the complaint. And we will now look to schedule a hearing on it, where we'll have an evidentiary hearing on that matter, and I'm going to look at July 8th.
Second.
Okay, okay. All right, so we'll put it on that date as well, July 8th here. It'll be an evidentiary hearing, and so the order will issue in the next few days, written to all parties, and the parties will get materials about our process, our hearing process in advance. Matters can be done, facts can come in by stipulations if there's undisputed facts. That's by choice, just by choice. But if you have any procedural questions, or you can speak with the Metro Clerk. There's a question about things that have to be filed in advance of the hearing, though, and they are, I believe, a list of witnesses and any documentations that are going to be used. Any witnesses? I mean, any documentation?
Yes.
There's, I think it's so many days before the hearing.
Yes, so if anyone wishes to submit material, the material must be filed with the clerk and provided to the other parties at least 7 calendar days prior to the hearing. And then also, each party must file with the clerk a list of the witnesses that the party intends to call at the hearing and provide a copy of the same to the other parties at least 7 calendar days prior to the hearing.
And that information will be included in the order.
Yes, ma'am.
So, and that will be in writing, and parties will receive that, so you'll have a record of that information. Okay. All right. I'm hearing no more, if there's no more discussion on that matter. We go to agenda item 7, next steps and scheduling. We now know we have the next meeting will be July 8th at 9 a.m. here. And any other matter, I'll just say kind of for the record, we are waiting to have a new member join us from the Central Labor Council to fill Mr. Patton's seat. Mr. Patton was sorely missed. So there will be a new member joining us at some point, so we will update you on that when we know someone's coming. Till then, are there any other scheduling or next step issues for discussion? Hearing none, then let's move to adjournment. May I have a motion to adjourn?
So moved.
Second? Okay, and I'll say all in favor, yes?
Yes.
All in favor, yes, and the meeting is adjourned. Thank you all.